Good morning. The Subcommittee for Indigenous Peoples of the United States will now come to order. The chair now recognizes the Honorable Ira Taken Alive, who is the Vice Chairman for the Standing Rock Sioux Tribe.
I'm present today to speak about environmental justice doctrine, specifically how after 2 decades since the President issued an executive order mandating that federal agencies consider environmental justice issues in their decision-making and how the agencies are still failing to properly consider environmental justice issues in their decision-making processes. The U.S. Army Corps' actions related to the Dakota Access Pipeline serve as perfect examples of a federal agency failing to properly consider environmental justice doctrine in its decision-making. The failure to address tribal concerns at the outset, coupled with the failure to seek alternatives that would not immediately endanger the health and safety of our people, led to controversy and costly litigation, where a federal court ultimately found that our concerns with the pipeline were correct and that the Dakota Access Pipeline and the Army Corps of Engineers failed to comply with federal law. The people of Standing Rock should not have to experience loss again for the sake of other communities and other people's gain.
We realize that there's still a need to discuss and incorporate with the Indigenous communities and see what environmental justice means to them. It's not a monolith concept. And while the injustices in Indigenous communities are widely known, they're very different from other marginalized communities in this country that also suffer the effects of environmental injustice. Mr. Vice Chairman, and thank you for being here and thank you for your testimony. In your position as a leader of the Standing Rock Sioux tribe, has the federal government's exploitation, for lack of a better word, of tribal land and resources, in your mind, violated the very essential part that is different from any other groups, and that has to do with the federal trust responsibility to tribes?
The ranking member Westerman had made reference to the executive order requiring meaningful tribal consultation. And in our experience, some of the agencies had counted making a phone call to our tribal office and leaving a voicemail message as a tribal consultation for the record in their findings.
I believe that the consultation process, how it's done, how it is uniformed, how it is enforced, how it is followed, what is the criteria, what is the checklist to make sure that it is meaningful in the full sense of the word, that is a part of responding to this environmental injustice issue that we're talking about generally. I think that either codifying that or formalizing that into something that's real, I think would be a huge part of dealing with this question.
Can you expand on the importance of water, especially the Missouri River, to your tribe, not just as a physical necessity, but also as a cultural resource or cultural landmark?
Oh, most certainly. We call the Missouri River Mini Sose, and it's a definite landmark. It has an important spiritual and cultural presence in our history and in our society. Most certainly at Standing Rock, we use the river for our main source of drinking water, but as well, we do have inherent treaty rights to hunting and fishing. And the lands that are along the river provide some of the best hunting, and certainly the cold waters, the deeper waters of the Missouri provide some of the best fishing. So the river is definitely important to us as a river tribe, and we do our darndest to protect it.
Too often, Indigenous voices are silenced or left out of key policy decisions, and this is especially true in the environmental justice movement. I don't need to remind everyone here that the exploitation of Indigenous communities is directly tied to exploitation of our natural resources, or that the economic interests are always prioritized over the rights of tribal communities or of our country's history of broken treaties. Environmental movements have not always been an ally to Indigenous peoples and communities. In fact, the early conservation movement in the U.S. lobbied to create the national park system that displaced and expelled Native peoples from their homelands and hunting grounds. We must ensure that Indigenous communities are not only part of the decision-making process, but leading these conversations. Anything less will simply perpetuate environmental injustice.
What does sovereignty look like? I think when a tribal government wants a natural resource economy, whether it be oil and gas or coal, that is their right as a sovereign government entity. It becomes a federal trust responsibility and an environmental justice problem when a tribal community does not want those projects. Or as Vice Chairman Ira Taken Alive said earlier, and I think I'm going to quote this, they are forced to sacrifice so others can gain. And we have seen that played out over and over. I also appreciate the witnesses' responses today in favor of codifying the government-to-government consultation process so it doesn't disappear when an administration, like we recently saw, doesn't care about tribal sovereignty.
And certainly, as Congressman Rosendale had mentioned, the quest for economic justice, as well as the quest for environmental justice, doesn't necessarily have to be in conflict. So a codification of the meaningful consultation process would be beneficial, because a lot of projects, as we've seen, and it was no different for the Dakota Access Pipeline, the permits necessary to conduct or install, construct the pipeline started at the state level as well. So when a project begins at the state level, it seems as though it's an automatic green light for continued construction. So a consultation process, meaningful consultation process at the outset of any project would definitely be welcomed.